I'm Matt Gishard, and this is No Holds Barred. Today we're going to talk about DUIs, driving under the influence. Driving under the influence in California, there are essentially people talk about 23152A and 23152B. But I want to say, looking at the vehicle code, there's not just A and B, there's C, D, E, and F. People talk about, I smoke marijuana. Can I drive? Can I have marijuana in the car? You cannot. But let's just go right into it and let's talk about it. What is 23152A? 23152, right out of the vehicle code, it is unlawful for a person who is under the influence of any alcoholic beverage or drug to drive a vehicle. And let me tell you, drug means that pain medication that you're taking, that sleep medication that you're taking, marijuana, any kind of drug, whether it be illegal, whether it be legal, whether it be a prescription, if it influences your ability to drive, if it impairs your driving, you can be held to be under the influence. That's 23152A. What is this 08 or above? That's 23152B. And generally, when people are arrested for driving under the influence, they're charged with both the A count and the B count. What is 23152B? Well, let's look at the vehicle code definition. It is unlawful for a person who has 0.08% or more by weight of alcohol in his or her blood to drive a vehicle. Interesting, when you start as a young DA in most offices, you do a lot of DUIs. Why is that? Well, sadly, because there are a lot of DUIs. That's kind of where you cut your teeth when you go to trial, is on DUIs. The limit used to be 0.10 back in the 80s, and it changed to 0.08. And why was that? Because impairment studies done by criminalists showed that every single person, for purposes of driving a vehicle, were under the influence at 0.08 or above. And how did they do that? Well, they had impairment studies. You get a whole bunch of people, you have them do a bunch of tests, typing a lot of tests before they drink, then you have them drink a certain amount, and you measure it, and you see how that impairs them. You have them go through the same thing. Counting, typing, doing FSTs. What are FSTs? Field sobriety tests. We call them balance and coordination tests. And then you have a whole body, and you statistically say that every single one of them, in some fashion or another, is impaired for purposes of driving at 0.08 or above. Well, you know, the neighbor who drinks all the time and can do all kinds of things, he seems to be in much better shape at 0.08 than somebody who hardly ever drinks and has 2 drinks and is totally bombed at 0.08. And the difference is no difference at all with respect to the law. That person who drinks all the time and has a certain capacity, what happens when the kid jumps out in front of him as he's driving down the road? He may believe he can drive home safely, but if there's something unusual that happens, that 0.08 impacts his ability to react quickly, and that's why the law is how it is. We often see people are 0.15, and at 0.15 we say that's where the gross manifestations, you start to see somebody who is slurring speech, whose balance is not so good, and most people at 0.15 or so are clearly impaired. What are the most dangerous drivers? Well, we often say the most dangerous drivers are those drivers between, say, 06, 10, 12. Why is that? Because many of those people do not believe they are impaired to the extent that they can't drive. So they take chances. They drive a little faster. They go in front of people a little faster. They pass perhaps when they shouldn't. So it's all bad. And we wonder every day why, with Uber, with rich people in their limousines, with all that, why are so many people continuing to drive under the influence of alcohol? I'm going to switch a little bit and say, let's talk about drugs. And the drug that comes most to mind is marijuana, because now it is legal to possess marijuana. It's legal to purchase marijuana, but guess what? It is not legal to smoke marijuana or ingest edibles and drive a motor vehicle. When we look at the various statutes, and I want to read some of them right out of what is 23-152F. It is unlawful for a person under the influence of any drug to drive a motor vehicle. So that's pain medications, that's anything. I had a good friend who had 3 DUI convictions, and he mentioned it to me one time, and in every case he was tested for alcohol, and in every case it came back 0-0. Well, he had injured his back years before, and he was on pain medications, and it clearly impaired his driving to the extent that he was involved in a couple of accidents, and one time the highway patrol was called because they observed his car driving down the road, weaving all over, and it wasn't alcohol. It was prescription pain medication. Critically important. All right, 23-152G. It is unlawful for a person under the influence, the combined influence of alcohol and any drug, to drive a vehicle. So I think the important thing that people need to understand, and we read about it in the paper all the time, critically important to understand, it's not just the humiliation of being arrested, paying the fines, maybe spending a day in jail, having to pick up trash along the freeway. It is the potential that you could seriously injure or kill somebody. And we read about it in the paper constantly. Some person partying with their friends, thought it was okay, got in their vehicle, driving home, caused an accident, and somebody died. Goodness gracious. So instead of just being a DUI, it's a vehicular manslaughter. If they've injured him seriously, it's a 23-153A or B, and that is driving under the influence, causing injury. Those were initially charged many times as a felony. Let's say someone broke a leg, but then it healed and they were fine and they cut a deal and got just a regular DUI. But don't take that chance. Now I do say, and how this kind of started, because somebody was asking me the other day about marijuana smoking and driving or ingesting. How many times you drive down the road and you smell that kind of skunk smell and think, oh, look around and there's the guy next to you, smoke's billowing out of the car, and he's smoking a joint. And he says, it relaxes me and I can drive very well. Well, that is against the law. You cannot smoke marijuana and drive. Something that people don't really appreciate, and guess what? It is that you've heard of open containers. That's a violation. If you have an open container in your car, even if you're not drinking it, you can be cited for open container. If you don't have a medical excuse, written excuse to have open marijuana in your vehicle, you can't have open marijuana in your vehicle. And people go, you can't have that joint sitting between the seats in a motor vehicle, just like an open container. If you legally can possess it, put it in the trunk, do something like that. So, or don't open the container that it's in. So most people do not know that. They don't understand. When I mentioned about 23-153, that is driving where you injure somebody, it can be a felony or a misdemeanor. I filed in Contra Costa County a number of years ago the very first case in which we charged a second-degree murder in a vehicular manslaughter case. And why did we do that? Well, we saw that LA County was doing it. We had a person who had 7 prior DUIs. One of them was a very, very serious accident, and the victim happened to live in Europe, had just been here on vacation and went home. In the history, though, we could see that the defendant knew the dangers and, in fact, had been a leader in the DUI classes that he had to take mandatorily to talk about the dangers. And nevertheless, he was on probation for one at the time of an event. He drove. He was on probation, and he had a restricted license that said he could go to and from work and to and from a treatment program. It was a weekend. He was not working, and he was not in a treatment program. He lived in one city. He was in a whole nother city. We don't know why. And he crossed the double line on a road and killed an individual. And we said, with his history, knowing what he knew, this was the classic case for Contra Costa County to finally get on board with filing second-degree murder. And what is that? Well, you know, on prior No Holds Barred, we've talked about second-degree murder. You load up a firearm and you point it towards that boxcar moving and you shoot, and you don't realize that there's a person inside that boxcar, a hobo, whatever, and you kill him. That's a second-degree murder. Why is that? Because you understand and appreciate the danger of loading that weapon and what that weapon can do. You didn't mean to kill somebody, but you shot purposefully, knowing that that bullet would exit that gun and enter. You didn't know it was going to kill somebody. Same thought. In that vehicle, you knew the danger. You've been through this before. You loaded that gun up and you fired it down the road. And as a result, you drove and you killed somebody. That is a second-degree murder. It's a killing with malice aforethought. And that, I can't emphasize enough, do not drink and drive. The marijuana that we have nowadays, yes, you can buy it legally, but you can't smoke it and drive. One of the benefits, unfortunately, for people that smoke marijuana and drive is that we don't have a per se rule. Per se means, as to 23-152B, that if you're driving with a blood alcohol level of 0.08 or above, you're under the influence and you can be arrested and prosecuted. With respect to marijuana, there is no level. And as we've known in the past, there are some people that can smoke a couple of joints and seem to be more relaxed and concentrate better. Other people take one hit and they can't find their belt. They're so messed up. Well, so we have a difficulty, but we have drug detection. We have police that are trained to look and see. So if somebody is driving, they smell the odor of marijuana on them, they give them nystagmus and believe that they're under the influence. And they put them through some balance and coordination tests and tests to the extent that the officer believes that the person is impaired. Now that is what the state has to prove. The state has to prove that for purposes of driving, that person with marijuana in his or her system is impaired for purposes of driving. And that's a little higher bar, and it's more difficult for the prosecution, but it nevertheless is the law. And don't just think that, well, if I smoke weed, what the heck, they can't really prove it. They can prove it in some circumstances. So please don't do that. Now, I do want to talk about, in the old days, and I want to say not very long ago, if someone was found in their vehicle, seated in their vehicle, the motor was off, they were not driving, but they were clearly under the influence. The police take them out, give them some field sobriety tests, and wow, this person should definitely not be driving. We didn't prosecute them for driving because they weren't driving. But the statute has changed. So if it can be shown that person was in the car, the keys are in the ignition, or they have possession of those keys, there's nobody else around. It's clear that they drove to where they got. They can be prosecuted for driving under the influence. So We had a funny case where a guy's out in the middle of an intersection, sound asleep in his car. The motor is running, the car is in drive, and his foot's on the gas pedal, on the brake pedal, and but I wasn't driving. The car was put, well, guess what? The statute also allows, under the vehicle code, that if you're involved in an accident. So let me go back for a minute and say, for a misdemeanor has to be committed in the presence of the officer in order for the officer to make an arrest. So in DUIs, we hear about it, the officer stopped somebody, saw the driving, contacts them, FSTs, test, all right, the officer. And in some cases, a person reports to the police, so this person weaving down the road, and they use that weaving down the road report from a citizen as probable cause. They find the car, it's parked on the side of the road with the driver in it, and they have to use the evidence from the person that saw them and observed. If there's an accident, the officer doesn't need that. An accident per se, the officer can, in fact, arrest somebody for driving under the influence. Now, I will say there are all kinds of ways, particularly as a former prosecutor, that we would think about, that's an interesting thing, how that person's defense was. We'd have the double refusal. What's a double refusal? Police officer stops somebody because they were weaving down the road or for whatever reason, believing that they were impaired, and says, I smell the odor of alcohol. Please step out of your vehicle. I'm going to have you do some balance and coordination tests, FSTs, field sobriety tests. Nope, not going to do it. Oh, so the officer says, well, then I'm going to arrest you for driving under the influence. So the officer arrests the person for driving under the influence, takes him and reads 13353 down at the station. You have to take a chemical test in the state of California in order to maintain your license. So, what do you want to take, a blood, breath, or urine? Nope, not taking a test. So then that person is charged with driving under the influence. As the prosecutor, we get the case and say, okay, we have the officer testifying he saw the car weaving, he smelled the odor of alcohol, but there are no field sobriety tests. Okay, well, how about the chemical test? Well, there's no chemical test. We call that a double refusal. Now, the jury gets to hear an instruction that says that he refused, and they get to hold that against him if they want to. But those are difficult cases. Other cases we've had where we had an accident, the car was parked there, the driver's nowhere to be found, and it was at nighttime, and drove down. I was riding with the Highway Patrol, drove down to a nearby store, and we used to call them a stop and rob, but it was a convenience store. And did you see a person? Yeah, a guy came in, he had blood on his forehead, and he bought a 6-pack of beers, and he went that away. So, okay, we run the vehicle, we find out where that person lived pretty close by. Went to the house and knocked on the door multiple times. Lights were on, but nobody answered the phone or the door. Well, don't get to kick it in and go in and find him. So guess what? That case was not a case that we were able to prove because we couldn't show that he was under the influence. In one other case, a similar kind of a case, the person did answer the door and invite us into the kitchen. And he was sitting at the kitchen table. He had a bottle of whiskey there, and he was drinking as fast as he could. Well, we couldn't show that at the time he was driving, he was under the influence. He was clearly under the influence now, and we couldn't show that, well, this alcohol now, you understand the problem. So there are all kinds of little tricks that people can if they're caught. But why would you want to be caught? Why would you want to go through that? In our little lessons on DUIs, I do want to go through a couple of things because young people often drive and under the influence, and we hear about that all the time. I do want to say that 23154A, one who is on probation for a DUI, so picked up for DUI on probation, they cannot have .01 or greater. So really no measurable amount of alcohol in their system. 23136A, one who is under 21 years of age cannot have 0.01 or above. In other words, no measurable amount of alcohol in their system at the time. Now, per se is that measurable amount. But what if an officer arrests them and believes that they're under the influence of drugs? Well, they can lose their license. An interesting story that I had was a kid was at a party, and he was a friend of the family's, and he was holding a beer on the sidewalk in front of a house. And the police pulled up and asked him how old he was, and he said he was 18. Well, he was in possession of alcohol. Minors have to remember, they can lose their driving privileges for being in possession of alcohol when they're under 21. They say, but I'm not driving. Doesn't matter. You can lose your license, and often does, your license privilege. So that's a big thing. So I have to kind of laugh and say, my older kids, when they be at a party, I said, well, I just want to tell you, if the police knock on the door, I don't want you standing anywhere near any alcohol, because the police officer can look inside and say, I see that person who appears to be a minor, and I can enter because it's a crime in my view, and I can ask them what their age is, and if they're under 21, I can write them a ticket for minor in possession. And you often hear people say, you can't come in here, you can't come in here. Well, if the officer can see marijuana smoke billowing inside or somebody holding a can, that all has to do with probable cause for that officer. So getting back then to driving, important for everyone to understand, don't do it. Another very important thing that I'll say finally is, under the law for the last few years, you can lose your license for driving under the influence, but you can have a DMV hearing so that you challenge that suspension. So how it works is, when you're arrested, in most cases the officer will take your license, actually physically take your license, and give you what we call a per se license. It's a pink sheet of paper, 8.5 by 11, and it's a license that you can use, you can show to a peace officer till the time of your arraignment, usually about 30 days out. If you get arrested within 10 days of the arrest, contact the Department of Motor Vehicles and schedule a hearing on your suspension. That will extend the time. And I've seen it as much as a year before a hearing was actually held for that suspension. In most cases, it's much less. But critically important for people to look in the back of that per se. There is a number, call that and schedule. If you have a lawyer, your lawyer will help you with that. But that's kind of important, because otherwise, after that 30-day period of time, your license is suspended. You cannot drive. Then you have to go through a process of getting permission through the Department of Motor Vehicles, if you go to alcohol classes, to get a license that lets you go to and from your work and to and from a treatment program. If you don't do that, you have what's called a suspended license, and it is the penalty for driving on a suspended license as a result of a DUI is greater than the DUI itself, the time that you have to spend incarcerated. So critically important, as I want to say here at the end, is don't do it. Don't drive. Take Uber, take whatever, take a taxi, have your friends. Do not drive under the influence of alcohol or drugs. Very important. So thank you very much for listening to this episode of No Holds Barred. If you have comments or questions, please enter them in the chat and hit the subscribe button, and stay tuned for our next episode of No Holds Barred.